Hi, everyone. I'm hoping you can hear me. This is a new experience for us all. My name is Jack Huskin, and I do Maryland workers' compensation with Chartwell Law, along with Steve Tregay. And I'd like to thank you all for attending inaugural webinar on Maryland workers' compensation. And I'd also like to thank the panelists that are speak today, starting with Commissioner Jeffrey Weinberg. And thank you, Your Honor, time out from hearings down in Beltsville to attend this webinar. Um, Next up is Mark Keim with Penn National Insurance. Mark is a senior claims representative for many years' experience, as well as Jim MacAlister with Cohen Steiner Katzen or Eisenberg and Katzenberg. Sorry about that, Jim. And Jim has many years of experience as well. Today, we're going to try to talk about medical control or lack thereof in Maryland workers' compensation claims, followed by permanency. We want to talk about mediations and settlements in Maryland. Given the time constraints, we'd ask that you hold off asking questions. We'll try to stop around 12:05 and just deal with questions at that point. If you have a question that you want to type in and have us all see while we're discussing a particular topic, you're welcome to do that, but most questions would probably wait until the end. So with that, let's talk about medical control in Maryland. A lot of states have statutory provisions specifying that the employer will have control of medical treatment over a particular period of time, beginning of the claim usually. But the Maryland Workers' Compensation statute doesn't specify that. And so we just wanted to explore ways of trying to control medical treatment in Maryland. And I would just start off with asking Mark Keim, how do you deal with issues regarding control of medical treatment in Maryland?
Well, with control of medical treatment, most of the time we will have to utilize an independent medical exam to potentially control the treatment. We do have employers that do have lists of doctors in place. They can make recommendations, but with the caveat, they tell the employee that they are not required to select a doctor from those lists, and they're free to choose whichever doctor that they want to. Some injured employees do choose those doctors, some don't. But really our only main control in stopping or changing direction of treatment would be through the independent medical exam.
What's the nurse case manager's role in that, if any?
Well, the nurse case manager can help in some situations. I think most doctors out there know that the patient does have the right to choose their own doctor. And while the nurse case manager can make suggestions, again, they're not locked or bound into what the nurse case manager says.
How about Jim? Do you have clients that sort of bounce around between treatment providers?
Well, generally, the biggest challenge to claimants is getting health care. And one of the dynamics, we all think, because we're so used to having Blue Cross and Blue Shield, that you walk into a doctor's office and they take your card and the bill gets paid. Well, with workers' compensation, it's a very different ballgame because the carrier has control from the standpoint that they approve or disapprove care. And as a result, a lot of healthcare providers won't see workers' comp claimants because, they basically want their bills paid. They don't want to buy a ticket to a fight that might get their bill paid at a later date. And also with regard to out-of-state healthcare providers, workers' compensation is very problematic because in Maryland, healthcare providers are required to accept payment per the fee schedule, which is a fee schedule set up by the commission as payment in full. They can't balance bill the client. They can't get a copay. When the client sees an out-of-state doctor, that doesn't apply. So the out-of-state doctor may or may not take the fee schedule payments. So where I run into the issues with the insurance companies is when they attempt to manage the care. And obviously I understand, it's a business and, you guys aren't writing carte blanche on the other side of this. There's some very effective ways to do this. Number one is I find nurse case managers are extremely helpful because there's sort of a liaison between the patient and the insurance company and the doctor's office. And most of my clients, I think, find that smooths over a lot of problems. So I don't wind up with denied care. It's cheaper than an IME because the IMEs are very expensive. And a lot of the IMEs that I get, it's like, sometimes I think they start at the bottom of the report and work their way back from no. So, and I think the commission sees that. When you're talking about healthcare within the first couple of months after the accident, I think most commissioners will approve whatever healthcare provider the client wants to see. Once you get further down the road and sort of further away from, we'll call it the gravitational pull of the injury, that's when you start seeing some serious questions come up, with treatment. But generally, I think if the client is seeing a doctor and is getting the healthcare they need right away, a lot of those people get better and get back to work. When healthcare is problematic for the first, and it's just a nonstop, fight to get everything approved, those cases seem to drag on further. So, did I answer your question?
Yes, and Your Honor, what is your take on that?
I agree with Jim. I think the nurse case managers are vital in certain cases. There's a lot of routine cases also. I do want to point out that there are several medical practices that I think a lot of insurers and lawyers are maybe a little skeptical about, but they do have a very important place in this. And this is where frequently lawyers will make referrals to these medical practices, but these medical practices are built to take standing treatment, may not get paid for. My experience with the main ones that are out there are they do a very good job of containing medical treatment. This whole workers' comp system, it's an ecosystem. And sometimes they treat, for a certain amount of time, but they know when to let go. So they also are very careful, the ones I'm thinking of, about prescribing narcotics. One of the most difficult areas for controlling medical treatment has to do with narcotics. And there, I think the role of the adjusters and the claims folks are very important. They're the first in line to see where they're paying for extraordinary amounts of prescription drugs. I think this has come up well under control compared to how it was a few years ago. But when they spot a problem, they can fill issues. And I know that I had numbers of cases where I cut off medical expenses if there was a plan in place from a qualified pain management physician who actually put the plan out there, and if it looked like a plan and the claimant didn't want to comply with that or couldn't comply with that, I wouldn't hold the insurer's feet paying all those medical bills. I would leave it to the extent that the plan called for these prescriptions. So, but again, in Maryland, it is claimant choice. And like Mark said, IMEs are the way to do it. Cutting off medical treatment without some backup, come into a hearing and you don't have any medical backup, treatment very well may go on. Commissioner might use common sense to say, yeah, this is a bumps and bruises case. 3-4 months of physical therapy is now getting into the excessive area. So, but you really ought to have your IMEs in line.
Well, I think from and hats off to the commission, I think they've been very aggressive and very diligent about the dealings of narcotic medications and the issues that have come up in the last few years. I think they've really taken a serious stance and really brought that under control.
Well, and one of the things I'd like to add is prescription drugs right now is a major issue at the Workers' Compensation Commission and in the appellate courts of Maryland, because under our fee schedule, there is no fee schedule for prescription drugs. So as recently as 6 months ago, the chairman of the Workers' Compensation Commission set all these prescription cases in front of him and issued a ruling that said Maryland is a patient choice jurisdiction, and the patient can go to the pharmacy or provider of his or her choice. Now, that leaves for another day fair and reasonable cost of the medicine, because one of the reasons that carriers try and steer patients to certain providers is because they can get the drugs cheaper. But the problem we have from the claimant's perspective is if those are fee-for-service providers and the carrier denies the prescriptions, my clients can't get their medication until they have a hearing, which takes 30 days to 3 or 4 months. So we send them to providers who will agree to fill the prescription and then wait for a hearing. And if the commission finds that the prescriptions are unnecessary or not causally related, then they write them off. So the difference is it fee for service, or is the client getting the prescriptions when they need them? And the issue currently is pending on appeal in the Circuit Court for Anne Arundel County as to whether the chairman correctly found that Maryland is a patient choice jurisdiction. So
what's the commission doing in terms of reimbursement for prescription?
Well, the chairman has told me that, and he's told everybody at hearings, that you're requiring, the regulations in Maryland require proof of reasonable and customary cost. So, the question is, what is reasonable and customary? If the pharmacy is a fee-for-service outfit, and then it has no unpaid receivables, so it sells the prescriptions at a low price. Rite Aid offsets the price of prescriptions by selling you soap and candy. And some large outfits in the country have affiliated themselves with insurance companies and are selling at discount prices. But what that equation or those equations don't answer is, how do we get prescription medicine to claimants that their treating doctors have prescribed, but the carriers have denied? And so the pricing structure for those pharmacies, the ones that will fill pending a hearing, is different than the fee-for-service outfit, because as we learned from the Obamacare debate, when there are unpaid medical bills, the hospitals don't just write them off, they raise the price for everybody else. They amortize the uncompensated receivables. So when you go into an emergency room, part of the bill you're paying is for the guy before you who didn't pay his bill, and the hospital's recouping that unpaid receivable. Well, same thing with the pharmacy. So the next debate that we're going to see at the commission is a debate over what is reasonable and customary. Is reasonable and customary what Rite Aid sells the prescription for? Is it reasonable and customary if the carrier can find some discount vendor who's got deals with the prescription manufacturers, even though those pricing structures don't take into account that the claimant needs the medicine and won't get it unless the carrier approves it? Or is the pricing structure take into consideration that, if you go to an outfit with uncompensated receivables because they fill prescriptions that the treating doctors want filled and then wait for a hearing, but when they lose, they write that off, their price, the reasonable and customary under the workers' compensation, it may be a different pricing structure, but that's the next big fight.
All right. I don't see if we have any questions on this topic, but it may be my screen because I don't know the system. As I said, everyone will have to excuse me if I have a technical malfunction, because I was just happy that I got the blue plastic covering off my lens so I could be here today. If there aren't any questions, we could try to hop over to permanency issues. And in Maryland, once a condition reaches maximum medical improvement, the peak, about as good as you're going to get, then the carrier with an MMI opinion can terminate temporary total disability indemnity. And then at that point, the injured worker would be rated for permanency. And the evaluating physicians, the IMEs on both sides, would be rating the impairment using the AMA Guide's 4th edition, as well as the Maryland 5 factors, which is a fudge figure that sort of overshadows the AMA Guide's 4th edition. Maryland 5 factors are atrophy, pain, weakness, loss of endurance, and range of motion. And so that fudge factor can really change the ratings once you get that in. Maryland does have a schedule of body parts that are provided maximum number of weeks of compensation for the loss of use of an arm or a finger or a foot or whatever. But if a body part isn't on the schedule, such as a neck or a back, you use a whole person impairment rating, which would be the whole person would be 500 weeks. And then if you have a 20% disability to the back, that ends up being 100 weeks. And then that's paid out over that course of 100 weeks after you get a hearing on it and a decision or a stipulation on that level of disability. And maybe I'll stop there. Jim, you want to continue on with, I don't know if we want to get into the tiers and all that kind of stuff.
Well, I think it's important to understand what permanency is designed to compensate. It's loss of future earning capacity. So in other words, if you're now a 3-legged racehorse when you used to be a thoroughbred, you know, your value as a participant in the economy is compromised. So what the Workers' Comp Act says is we're going to look at it basically 2, sometimes 3 factors. The first is, we have you seen by a doctor who rates impairment. Impairment is what's wrong with you. And they look at the AMA guides and those 5 factors and they put down a percentage. But that's just what's wrong with you. Then the claimant testifies at the hearing, how does this affect my ability to do my job? Meaning, how is my ability to function as a racehorse that I used to be compromised by the impairment? And in cases where you're, you know, that are called other cases, which is basically anything from the hips to the top of the head, you know, anything from the shoulders in, basically the trunk of the body and the head. Under other cases, we also want to know, are you making more money, less money, or the same money as you were? Because essentially permanency works like this. If you have an injury to the right hand that leaves you with an impairment, and your impairment is, let's say, 30% of the hand, and you're the quarterback for the Baltimore Ravens, you've got a lot of disability. But if you're a soccer player, where it's against the rules for you to touch the ball with your hand, you've got no disability, yet you have the same impairment. So that's really what permanency is designed to do. So, and essentially what they're trying to figure out is how much lighter in terms of future earning capacity is your paycheck going to be in the future. So they look at all those factors and they come up with a percentage of disability. And the percentage of disability is plugged into the body part. So if the leg is worth 300 weeks and you got 10% of the leg, you're getting 30 weeks. Does that mean that on the 31st week, miraculously, you leap from bed and are healed? No, they're trying to come up with a number, and that's how they calculate the number. Now, how much you get per week depends on how many weeks you get, just to make this more complicated so that you feel good filling out your income tax by yourself. But if you get 75 weeks or more, the amount you get per week just about doubles. If you get 250 weeks or more, you're said to have serious disability. That's the jackpot because you're paid at a higher rate even, and you get a one-third increase in the number of weeks. So most of the cases, I think, and Commissioner Weinberg, correct me if I'm wrong, I think falls somewhere between the first and second tier. And that's sort of where most of the, you know, we want it to be 75 weeks or more, and the insurance companies want it to be 75 weeks or less. And my experience with the commissioners is if you have a non-surgical back injury, soft tissue injury, unless your client really has been deprived of the ability to make a living and can demonstrate that, you're getting a first tier award. You're getting, you know, something between 0 and 74 weeks. If you had a surgery, and again, only in Maryland and, you know, workers' comp, does somebody have a surgery that makes them better than they were before they had the surgery, and they have more disability than the guy who didn't have the surgery. So, I mean, Commissioner Weinberg, what are your thoughts on that?
Well, one of the thoughts is that if you look at the statute for permanent partial disability, one of the factors is the nature of the injury. If there's a surgery, generally there's some disruption or some structural change in the body. So when you're looking towards this future loss of earning capacity, that can be a factor. It's a lot of subjective analysis that goes on into finding the percentage of disability. And I agree with Jim that, surgery is and always has been. I practiced for 29 years. I was on the commission for a little over 11 years and been mediating for the past few years. And this concept has just always been a piece of this business. So, but you can have non-surgical cases that could be permanent total cases. So, really depends on the individual. Just like Jim was comparing the soccer player with the hand to the quarterback.
I think this system is set up to some extent reward folks that are working. A wage law state like Pennsylvania that rewards folks for not working by paying their wages or temporary total disability indemnity until they do go back to work, essentially.
Well, and I think one of the factors also that I've seen, for those of you who work with employers, is if the employer takes the employee back and is making efforts to accommodate the employee, most of the commissioners are less likely to go to second tier or serious disability, because they sort of say, well, if the employer is bending over backwards to keep the employee on the payrolls, then we're not going to hit you with a high award. So, that's one of the things I've seen.
That's a great point, Jim. That's why, from our end, we're always pushing employers to make sure the employees back to work, whether it's in a sedentary job, light duty, whatever, because in the ultimate end, you're right. If somebody's back to work, it's less likely to go to a second tier. And you get your exams. Your exams are usually second tier. Ours are usually first tier, and it's always met somewhere in the middle when we either stipulate it or a decision comes down, and it's right in that 75-week area, and you're always wondering, well, are they going to get second tier or not?
Right. And this is a little bit off topic, but another reason it's good to get these people back with the employer is if it turns out that the employer won't take them back, you're looking at a claim for vocational rehabilitation. Well, getting somebody a new job, set up in a new career, while you're paying them 2/3 of their average weekly wage, temporary total, is a lot more expensive from the carrier's perspective. And it's a lot, on a personal note, it's very disruptive for the injured worker. I mean, a lot of these people have worked for these employers for 5, 10, 15 years, and all of a sudden you're out in the street and now you have to start your life over again. That becomes a very expensive proposition for the carrier. So again, I always encourage claimants and, employers, whenever I get a chance to talk to them, keep these people on the books if you can. When you get your workers' compensation premium bill the next year, you'll be glad you did.
Not to move on, but on worsening, I was curious, Jim. Do any of your clients not worsen within 5 years from the last payment of compensation?
Well,
Loaded question.
I mean, yeah, the way Maryland works is this. You get a check for compensation, either temporary total or permanency, as long as compensation is, in Maryland is defined as money paid to the claimant. They have 5 years from that date to reopen for worsening of condition. If they don't reopen within 5 years, their indemnity benefits are dead. And as I say, that's the right to get a surgery 6 years from now that you can't afford to take the time off to get. So if you have, most of us have a diary where, 2 or 3 years from the last payment of compensation, we reach out to the claimant and say, how are you doing? Now, we only get paid if we win, and reopening a case is not necessarily easy because, if the claimant says, I have the same problems as I had before, they got a permanent award because it was supposed to not change. So, but to make a case for permanency worsening, you need some medical treatment. You need either that or some organic change on an MRI report, because, if you reopen, you're going to need to spend, $700,000-800,000 on a rating report. And if the rating report comes back, and your claimant gets $1,000 increase, that's good because it bumps their case. That's considered a payment of compensation. So that gives them another 5 years. But, if the claimant really hasn't worsened in 5 years, that's when I reach out to the insurance company and say, let's talk about a full and final settlement potentially, because, the carriers are as interested in getting these reserves off the books as we are resolving cases that aren't going to worsen.
That's it for I don't know if it's happened in your experience, but I just, in a case that's coming up for hearing, I got a claimant's IME report that found no worsening.
You're going to want to hold on to that because, like a winning lottery ticket, that's something, if you're lucky, you only see once in a lifetime on the defense side.
Let's see.
I will say that because I understand our audience is mostly claims handlers and supervisors and that sort of thing, but I think on a petition to reopen, just a little first thing you look at is when was the last payment of compensation, and then whether there's been any intervening injuries, and should it proceed further, it's very helpful to the commissioners to have the same IME doctor that rated the first time around do it the second time around. It provides consistency.
And talking about worsening, Your Honor, how does the commission view worsening in terms, you mentioned wanting the same IME initially and then subsequently for the worsening litigation?
It's not always possible for the carrier to do that. Doctors retire, doctors move around, but it just gives us further consistency. Obviously, what we're looking at is what was the condition at the time of the last award and what changes since then. So, the amount of treatment is a big factor. What kind of work was the person doing at the time of the last award? What are they doing now? Less money, more money, surgeries intervening. But again, it's that subjective thing that commissioners have to look at, taking medical records and ratings into account.
And that's what if a carrier, if the initial employer report, IME, is a little on the light side, it's sometimes difficult to get it to jibe with the report on the worsening side. Mainly, if the initial report is really low on permanency or has sort of a strange apportionment opinion, if that doctor is no longer available and you go to another doctor, you could get like an opinion that really doesn't jibe with the amount of worsening from the initial examination.
Well, there are certain doctors out there on both sides. There are several on the defense side who I've always had great skepticism as to their credibility. They've already made a record for themselves by consistently making negative findings that just don't fit. They may leave certain important factors out of their report. When you've got a situation like that and you want to get a more realistic look at the value of the case, to get somebody who is more realistic can be of benefit to the insurance company, then you kind of know where you're headed in the case.
So the commission doesn't ding you if you get a reasonable report on worsening when you had one of those reports that doesn't make a lot of sense initially?
Well, you have to remember there are 9 commissioners and the chairman also sits, so there's 10 factors out there. it's difficult to know generally, how a case will come out, but there are certain similarities that you see in cases that you can sort of get a pattern to it and go from there.
And I add, when you're scheduling the IME, make sure your expert has the report from the last IME. I can't tell you how many times I've, done a cross-examination of a doctor in a workers' comp appeal and said, well, doctor, you think that this guy's got this, what about Dr. So-and-so? Oh, I didn't know he saw that, So the way to perhaps head off the inconsistency potentially is to make sure your expert is aware up front that there was a prior finding.
Actually, it's about 12:30, so maybe we can start talking about mediations and settlements. And Your Honor, most mediations take place while a workers' compensation case is on appeal. Is that right?
I would say the majority of them are. In my experience, I get maybe 20% thereabout of cases that the parties want to try to resolve before they get to the Workers' Compensation Commission for a multiple of reasons. One of the biggest reasons is there's certain complexity in the case, and if they can resolve those complexities without a hearing, number one, mediations make things a little bit cheaper than going to court, because if it's a case that's likely to go up on appeal, then there are lots of expenses with that. The mediations that I do pre-hearing usually are with very good experienced lawyers, and they see what the problems are. But yeah, most of them are from appeal cases. And some counties in Maryland require at least one bona fide effort at mediation.
Why doesn't the commission require that at the commission level?
To add that extra level would it would be unmanageable. Hearings at the commission, we had a big delay because of the COVID-19, but up until that time, the commission is a very, very efficient machine. We would, as commissioners, handle starting with 20, 22 cases on a docket. By the time we get to the hearing date, it could be 15 or 16. By the time postponement requests and stipulations come in, they're trying 10 to 12 cases a day, and they're punching out hundreds and hundreds of decisions a month. So they're already very efficient, and the mediation, I think, would just add an impossible layer and also a delay. Because mediation, the parties are not bound by anything. In fact, the mediator cannot tell the parties what to do. As a commissioner, and I tell, at every mediation, I tell the parties, this particularly the injured worker, that, as a commissioner, my job was to make the decisions. I could tell people what they had to do. You got to pay this medical bill. You got to pay this permanency. Of course, they could appeal it. But the mediator's function is to remain neutral and impartial, take neither side, can't tell the parties what to do. They have to come up with their own resolution. The mediator can point out certain things, ask pointed questions, offer some experience as to what the outcomes might be. But mediations at the commission level just would never work.
Well, let me follow up on what Commissioner Weinberg said. One of the things I found is very effective is before there's an appeal, because and mediation isn't for every case. If somebody hurt their finger, you don't mediate that case. But in cases where somebody's been off for a while or somebody's having difficulties and these issues are coming up, a mediation is an opportunity for everybody to stop and focus on trying to get the case resolved. And before we started, doing mediations, and I do almost exclusively workers' compensation appeals. I think one of the few lawyers in Maryland that does that. But, I handle a lot of hearings as well. But, what I found was we're walking into courthouses with our witnesses, and the judge is like, have you guys talked settlement at all? So the court started requiring mediation in Maryland. And I'll bet I've gone from trying 2 or 3 comp appeals a month to I don't think I've tried one in 5 months. So it's very effective. It's cost effective because, and Commissioner Weinberg is an excellent example of somebody who brings to the table not just the experience of a commissioner, but somebody as claimants counsel as well. So he's very, those sorts of mediators can sit down and say, here's how we're going to get this case settled, or here's how you resolve this issue. Because to settle a case in Maryland, the price has to be right, meaning the dollar amount has to be correct. But also the commission requires that we not shift the cost of accident-related medical care to the Medicare. And so there are creative ways of doing that a good mediator, I can't tell you how many times I've walked into a mediation and said, I'm going to watch the sun come up in the west tomorrow if I get this case settled. And I wind up waking up the next day just to see if it came up in the west, because, stopping, concentrating, and focusing. And like I said, there are very creative ways that a good mediator can help you settle a case that you swore couldn't be settled. And the worst thing that happens is if it doesn't pan out, you spent $250 for 2 hours of Commissioner Weinberg's time. And what that also helps, especially from the defense perspective where you're paying your lawyer by the hour, is it focuses the issues, because everybody sits down, pauses, and says, what's this case really about? What's the sticking point? And a lot of times you leave mediation perhaps not with a settled case, but with a dispute resolved in a way that makes the claim move more smoothly. And when it's not moving smoothly from the defense perspective, you're like the guy sitting in the back of a New York cab with an out-of-town accent. You're spending a lot of money fighting these issues. So mediation is a great idea.
Well, and I think the key, like you said, Jim, is we want to try to mediate the case before we spend all that money to bring doctors in to testify, to bring other witnesses in, and also to continue to pay Jack's hourly fee. We like to try to get these things resolved if we can, because it's a win-win for both parties to get the case resolved. It allows the employee to move on with their life, and of course, from a workers' comp carrier standpoint, you've got a closed claim.
Yeah. And one of the things I've found is effective is you call up somebody like Commissioner Weinberg and say, let's book you 2 months from now for a morning. And then you contact, 5 or 6 claimants lawyers that have cases that you guys are really, either going at it or you just can't agree or it just seem problematic. Sit down, book his time, book a morning. And when we've done that, we've knocked out, a lot of claims that we swore would never pan out. So that's a way of sort of pushing yourself to mediate these cases more by setting up a structured process.
And in Maryland, you can settle cases in full. It's the commission, though, is very careful about protecting Medicare's interest. Your Honor, talk about that?
About protecting Medicare's interest?
Or the commission's policy on how to get a settlement through if the parties don't dispute that a work-related injury took place, or there's some medical opinion that there's no need for further medical treatment. The commission requires medical cost projections with the settlement?
Well, it depends on the case, but what the commissioners are looking at, and there's a number of things they have to look at, but I would say one of the primary things is, has future medical treatment for this injured worker been addressed in the settlement? Sometimes completely cutting it off, a full and final with no future medical, that's the appropriate thing to do. But there are other cases, as Jack says, requires a medical cost projection. There are others that require a formal medical set aside, because you may have CMS and Medicare implications. So, if you want the details, the Medicare Secondary Act requires that Medicare be the secondary payer, and if there's a primary payer, such as workers' comp, they should be first in line. So you want to make sure that the settlement has the language that Medicare's interest has been addressed, And also the liability for insurers and employers probably is far greater, although there is potential exposure for attorneys and injured workers and employers. Anybody could be subject to assessments and fines and treble damages for not protecting Medicare's interests. So you really just have to look at and question if it's the appropriate case. Is the claimant on Medicare? And if so, if there's a settlement of $25,000 or more, you have to go get a formal Medicare set aside, and you have to get CMS approval. Or if the settlement's $250,000 or more, and you have somebody who's likely expecting to get Medicare, then again you have to submit the medical analysis to CMS. These are thresholds. There's no safe haven in Medicare. They could take a look at any case if they want to. They generally don't, because they have to look at what their case backlog is and just do the ones that are most likely to affect them. But there are serious consequences of not protecting Medicare.
If someone has a back injury and they over the years have additional segments involved, if these additional segments haven't been adjudicated as causally related to the work injury, is the commission in a position to issue an order in the course of trying to settle that case that these additional body parts aren't related?
If there's a cogent medical opinion that's credible, then yes. I mean, the commission can rule either way. I think, medical opinions are some of the most important things we look at. And again, we see the stable of doctors from the defense side as well as from the claimant side. And most of the commissioners get used to seeing these reports, and they know how to interpret them. Just like the ratings. We see certain doctors, we know their ratings are way too high or they're way too low. We have criteria that we can look at. And I just want to, so the audience understands, everybody's calling me commissioner, and I'm actually retired, so I do recall, and that's what allows me to do mediations. I just wanted to clarify that.
Oh, thank you. You're on.
And Jack, let me follow up on that, because this is where the creative minds of the parties with a good mediator comes in. So let's say my client, I'll give you a hypothetical. My client had a back surgery before the accidental injury, 10 years before. He then has a back injury that does not result in surgery. And we're getting ready to settle the case. And, I filed issues for surgery. And, basically the commission issued an order finding that any future back surgery is not causally related to the accidental injury. Now, there was a colorable basis for that because I had the defense IME and I had the doctor who had performed the back surgery, 10 years ago saying my client doesn't need back surgery as a result of the accident. But now I have an order from the commission saying that's not related. Now, if I hadn't gotten that and the claimant later on in life had wound up on Medicare, somebody in Medicare might say, well, wait a minute, this is related to that accidental injury. If you have something that's in a contested posture, either a medical issue or the claim's contested as to accidental injury or occupational disease, if you settle before the commission makes a decision that something's causally related, then usually you can get an order as part of the settlement. At least people on my side of the net will say, yeah, we're willing to give that up, assuming the price is right on the indemnity side. So that's where working with a good mediator is important, because those are the sorts of ways that you can, get these cases settled. Because otherwise, if you send it to CMS and a back surgery is even mentioned anywhere in the records, they're going to come back and require that the Medicare set aside be $200,000 before they'll, approve the set aside. So there are ways of managing your exposure with a good mediator that can get these cases settled.
Just
Right. And also, it's also, I think, important to consider leaving medical open in the appropriate case, which can be far cheaper than what you may pay out in a even if it's an annuity, but the future medical costs could be cheaper by just paying as you go, even though you have a settled case. I understand the motivation to have a full and final and close it out with no more case management, but there are cases where it could be appropriate to keep medicals open.
Yeah, there definitely are cases where that is appropriate, and especially in cases where we may be paying ongoing wage loss, it may be appropriate to settle the indemnity portion of the case and then develop some additional medical evidence to submit to CMS to potentially get a lower set aside down the road.
Yep.
And let me also make a pitch for leaving the medicals open. I mean, most claimants, if they're not going out and getting medical treatment on a regular basis, or they go once a year or something like that, and you're making a payment pursuant to the fee schedule for a one-time visit a year, versus getting some set aside that projects, there's a back surgery or something else in the offing, or especially if there are opiates involved, you just, leave the medicals open. You'll probably never hear from these people. So, and I find a lot of carriers don't like to do that because they prefer a divorce than a separation. But I think it in a lot of cases, it would probably be a lot cheaper to leave the medicals open than close it.
And settlement, I think, also has a tremendous value in, I think every carrier has their examples of the case. We could have settled this for X amount of dollars, which may have been more than the case was worth at the time, but now the case has exploded. And now we're on failed back surgeries and pain management, and you're paying tons of money out on a case that could have been settled. So it is extraordinarily important to look ahead and not just, what are we facing today? So those are just some thoughts.
I think every adjuster has a file on their desk that's just like that.
Right. It's the biggest fear, isn't it?
Yes.
Okay.
I don't know if there are any questions out there, or if we want to move on, since we have some time, and talk about vocational rehabilitation. You had mentioned that before, Jim.
So basically, a Maryland workers' compensation claim has two phases. One we'll call the healing up phase, or the temporary total, or somebody's missing lost wages because they're undergoing curative healthcare that's designed to improve their overall health. It's healing care. At some point, the claimant gets the maximum medical improvement, meaning they're not going to get, they're as good as medical science can get them. And at that point, they go from being in the heal up stage to the permanency stage. The permanency stage has three important benefits. One is perm total. If the person's permanently and totally disabled, they get 2/3 of their average weekly wage for the rest of their life. If the person is permanently and partially disabled, meaning they're back to work, but it's hindering or handicapping their ability to work, that's what partial disability is. If they're not working but are capable of returning to work, notwithstanding the limitations that keep them from doing their job, then they're eligible for vocational rehabilitation. Vocational rehabilitation has a couple of steps. The first thing is you get a report from a doctor that says the claimant is unable to go back to doing the type of work they were doing. The second is a functional capacity evaluation is done, and that is essentially what can the person not do. And they're physical therapists. They put the client through a series of exercises and lifts, and they basically test how long they can stand, lift, and they come up with an opinion as to whether they're heavy duty, light duty, medium duty, or sedentary duty, or incapable of working. Then a vocational rehabilitation counselor, a voc counselor. These are licensed independent counselors, licensed through the Maryland Workers' Compensation Commission. They do not work for the insurance company. And they're paid to sit down with the claimant and come up with a plan to get the claimant back to work. Generally, I would say 90% of the plans involve job placement. And the goal is to find the claimant comparable substitute employment. Well, what's comparable? Because the claimant can't return to doing the sort of work they were doing. Comparable generally means making something around what they were making in a similar type of environment. If placement doesn't work, then there's training. It's tough to get training as a first ask from the claimant's perspective, because usually most of these people can return to work, and the counselors are pretty good at getting that done. So that's how it works, and then the counselor reports back as to how the efforts to do placement are working. It's important that the counselor reach out to claimant's counsel anytime there's a problem, so that we can head something off before it becomes an issue. But also, if the carrier finds out there's a problem, contact the claimant's counsel so that we can contact the client, because the best kind of problem with vocational rehabilitation is the one that goes away versus one that becomes a problem because the claimant's like, well, I'm not happy with the counselor because they're sending me on the wrong jobs, so I'm not going to do it. Or they're showing up in sweatpants, reeking of alcohol at job interviews. These are things and to inhibit people's return to work. And, a lot of times we can have I call the come to Jesus moment with the claimant, where you say, if you want your money, you will return to work, because commissioners are pretty good at seeing through people that aren't cooperating, and they tend to cut off voc rehab for those people. And people that are doing a good job, they tend to subscribe to what Ben Franklin said, which is the Lord helps those who help themselves. So, but I think an important aspect of voc is a dialogue between the adjuster, the voc rehab provider, and claimant's counsel that smooths out any problems with the claimant, or perceived problems perhaps, before they become an issue that starts requiring hearings.
How about,
Jack?
Your Honor, yes.
Excuse me for interrupting. This is the conference producer. I just want to let everyone know how they can ask a question. We have a few minutes left, and I know Commissioner Weinberg has a tight schedule. If you would like to ask
I did catch a break, though, where I have a few extra minutes if you need it.
At the bottom center of your screen, if the participants would like to pose a question, you can simply type in the Q&A balloon or the chat balloon. Or if you want to raise your hand and ask a question audibly, there's a little hand icon on the left side of your screen, lower left side of your screen. You can hit that, and our producer, Maggie O'Connell, will announce that you're unmuted and you can pose your question. At that point, I'll turn it over back to you, Jack.
Well, thank you. Commissioner, how does the commission or you view the vocational rehabilitation process? Because I used to practice in California at a time where the legislature got rid of the whole system. And sometimes I view it, as I did back then, that some of these folks are just going through the process to extend out their wage loss benefits.
You run into the entire spectrum of humanity in these issues. And there are those that use the process as a bridge between maximum medical improvement and getting permanent disability money. There are those who don't want to go back to work. And if it becomes obvious to a commissioner, I know that I discounted the value of permanency on those that didn't try to help themselves. Those that were sincere and a good voc rehab counselor couldn't find work for that person, that increased the possibilities of serious disability or even potential permanent total disability. The game that the injured worker puts in there, either pay off or And there are a lot of cases where the injured worker actually hangs themselves with their case by not cooperating and making it obvious.
I want to echo one of the things Commissioner Weinberg just said. That the best defense to a perm total claim or a serious disability claim is voc rehab. Because, you know, if you voc the guy or woman and they are truly uncooperative, then, you know, it destroys the value of the claimant's claim. If they are successful, that gives everybody, including the carrier, a very clear idea that, you know, this is somebody who's represents a serious exposure, and you know, you can operate from a point of actions have spoken louder than words, and you now know this person really is messed up, and sit down and look at it as an exposure that has been proven, again, by the claimant's actions and going through voc rehab.
And actually, I'll just interrupt because we have a question with respect to permanent disability awards, whether multiple body parts elevate the case to the second tier. In other words, is 5% to the head and 5% psychological 50 weeks going to multiply by the first tier rate or the second tier rate? So,
Well, I can speak for myself that, you know, the case that the claimant has an injury, goes to the emergency room, goes to the attorney sends them out for treatment, and it's minimal treatment, you know, 2-3 months physical therapy, minimal lost time. You could have 10 body parts that might total 150%, but it's still a minimum lost wage, return to work to the same job, and that's not going to be a second tier case, at least to me.
and that's why you multiply, you rate out the body parts to the weeks equivalent, and then you add up all of those weeks to determine where that case is going to land, whether it's first tier, second tier, or serious disability.
Well, my experience has been there's two ways of approaching that. Number one is we talked about all the scheduled members, you know, like a leg is worth 300 weeks, a foot's worth 250 weeks. So if you have two body parts, the commissioner can look at it one of two ways. They can either say, okay, so you've got a foot and a leg, each, like you hurt your knee and you also hurt your foot. And they add up the total number of weeks for each body part. And if that's above 75 weeks, it's above 75 weeks if it's not. Because those are scheduled members, whether the person is making more money or not, meaning industrial loss of use, is not an issue. So remember when I said there's 2, sometimes 3 factors. If you're dealing with just the scheduled body parts, loss of income, earning, you know, loss of making less money is not an issue. Now, if you have more than 2 body parts, you can also ask for a ruling as the body. So, you know, under that, you know, foot and ankle, I mean, the leg and foot case, if my client is making substantially more money, I want the commissioner to find a foot and a leg, because whether he's making more money or not isn't an issue. But if my client's making a lot less money, I tell the commissioner, because there's more than one body part, I want you to make a body finding. Well, when you make a body finding, the issues are impairment, disability, and are they making more money or less money? Well, somebody that's making a lot less money looks a lot more disabled and usually gets a higher, award than somebody who just has 2 body parts and is making more money.
That's the kind of case where if I see that, you know, it's a good motivated claimant and they have these 2 injuries, and even though they may be making more money, with the seriousness of the injuries, you know, if it's getting the second tier and it's 2 body parts, it's probably not super serious. But if I'm looking to get to second tier because I think this particular claimant deserves it, then I would isolate one body part, give a percentage for it, and do the other body part or parts separately to get to the 75 weeks, because it's harder to do with an industrial loss.
And I think we're about at 1 o'clock, so folks that have to leave at 1, I just wanted to thank you all for attending. And if we want to do this in the future, let us know. And I hope it's been helpful for you. And even though it's 1 o'clock, if we have a couple of minutes, we can continue our discussion if your honor's available, Jim and Mark.
Sure.
Yeah, I think I got about 5, tops 10 minutes, because I have another case coming out. I'm doing hearings today.
New auto parked on 3. New auto parked on 3.
I guess that's not a question. But let's see. And actually, I think we've covered everything that I was intending to cover. So,
Well, I do have a message from Mary Ahern, the executive director of the Workers' Comp Commission. I asked her, is there anything that she would want to express to those that are handling claims? She said that if you get a Form C-40 and it has the wrong carrier in there, complete the form anyway, give the correct information. And her other message is that if you're trying to get in touch with anybody at the commission, take a look at the annual report, which is online. And it has everybody at the commission and their departments listed, which leads me to remind everybody that when you do have questions, the answers are almost always in the statute, the regulations, or on the website. And the website is a wealth of information. I encourage anybody who hasn't looked at it with the Maryland case, look at it. You'll see how much information is in there, and it's very, very helpful.
yeah, I think the contact information is on the home page at the top left. There's a little line where it says contact, and then you can get into all the contact information for all the commissioners.
This is more than that. This is, for compliance issues, whatever you have for the different departments.
Well, not only thanking the folks that attended, thank you panel, Mark, Commissioner Weinberg, and Jim for doing this panel today. I really appreciate it, and the firm does, and I enjoyed it. I hope you all did too, and maybe we can do it again sometime.
No, thanks for putting this together. One of my pet peeves in handling comp cases is we don't talk to the other side often enough to, so that we get an appreciation of what you folks are up against. And I think the more we know about each other, the better dialogue we have. And ultimately, the people that benefit from that are the claimants and their employers. So,
well, during the pandemic, I just want to talk to anyone.
Well, I'm glad I returned your calls then, Jack.
That's right.
Let me, if I could say one more thing though, these types of webinars and previously seminars, I think they're just, I don't know how to express how important they are, because if you've learned nothing today, but you've had your practices reinforced as being proper and appropriate, that by itself makes these things worthwhile. Anything you learn is just icing on the cake. And I want to thank Jack for inviting me to do this.
likewise.
And all the attendees as well, and the panel.
Well, thank you all. If there's nothing else, let's see, Sharon, do I stop the webinar, or do you?
We'll handle it. You can just hit leave at the bottom. Thank you all very much for participating. If you have any questions for Jack, you can email him at jhuskin@chartwelllaw.com.
Excellent.
Thank you.
Thanks a lot.
Thank you all.
Yep.
Bye.
Bye.